When can you get a judge kicked off of the bench during a particular case? What that is called is the recusal process. And in criminal proceedings, if a judge is so immutably biased that it would render the entire trial proceeding unfair or unconstitutional, that judge is required to recuse themselves. Now, what if you have a judge, as in most instances, where the issue of potential bias is raised in their particular court and they come back and say, well, I really feel like, I can rule on this matter without being biased. Well, the next thing to do is to file a motion to recuse, and a lot of defendants may not know that they can do that. In certain instances, you are enabled to file such a motion. And that motion, unfortunately, goes right to that judge that you are asking to recuse themselves. You can almost, pretty much bet on what the answer to that motion is going to be: denied. There are actually two things that you may do. You may file what's called an interlocutory appeal of that denial. So what that means is you go to your state's higher court and you say, hey, listen, there's clearly a biasness with this judge. We filed a motion to recuse, and that judge did not recuse themselves. So the proceeding that judge is overseeing comes to a screeching halt while the state's higher court makes a decision on whether or not he or she should recuse themselves. Now, another method is to file what's called a writ of mandamus, also filed in your state's high court. Mandamus is a Latin word that simply means compel. So you're saying to the higher court, we are asking that you issue an order compelling that biased judge to recuse themselves so that the person may have a fair trial. Just because you have a judge on the bench doesn't mean he or she has to stay on that case if you have evidence that they're biased.